I said I would do a little bit more on responsible corporate officer doctrine, and there were certain qualifications, and that's what you want me to do, right? Okay. It's not just sufficient to find a responsible corporate officer. The courts have said that that officer also has to be in a position that has the authority and the responsibility for the particular situation. That, of course, will vary from corporation to corporation depending upon how it is organized. And in addition, there's been the recognition that there is an affirmative defense that can be offered by that person to the effect, if he can produce or she can produce evidence that the person was, quote, powerless to do anything about the situation, although I would imagine that's a pretty tough standard to meet. Ultimately, it is said the government bears the burden of proof beyond a reasonable doubt, but the corporate officer bears the burden of going forward with the defense. In Britain, which I cited in the slide, the defendant really wasn't claiming not to be a corporate officer, and it was kind of a side issue. He was claiming that he wasn't covered because the statute actually referred to a responsible corporate officer, and that's one of the few statutes that Andrew was referring to. There are relatively few statutes that actually identify these situations, that is, are specific to corporations. This one did, and the defendant was arguing the negative, that, well, I'm not a responsible corporate officer, so I'm not covered. And it was almost not an issue in the case because he was otherwise liable, and it was a clear case of liability on his part in that case. But the case does emphasize that they're dealing in responsible corporate officer discussions with misdemeanors, and that's the way the understanding had been. And I mentioned that in McDonald, in the antitrust cases, the court had distinguished public welfare doctrines in terms of whether we were dealing with a misdemeanor or a felony. Well, in McDonald and Watson, which I also mentioned and I'm coming back to, it was a circular conviction that required knowledge. And the court made the distinction that it was an error to charge that proof of one is a responsible corporate officer necessarily proves, quote, knowledge. And it made the important distinction that if one is being charged as a responsible corporate officer in a public welfare offense case, the public welfare offense doesn't require a mens rea. Therefore, when charging the officer, there is no requirement of a mens rea. Here, however, the statute required a mens rea, and the government tried to get around the mens rea requirement by saying he was a responsible corporate officer. But that had been borrowed from the strict liability cases and had been up to the felony case. So you can see this tension that I referred to. If you escalate the public welfare doctrine beyond its original confines, you not only implicate the corporation, you implicate the possibility of extending liability, which was Jeff's point, beyond into individuals. Jeff may be a little more concerned about corporations than I am. I'm more concerned about the individuals and the impact upon them. Now, that certainly doesn't take up my 15 minutes, and I probably won't take up the whole 15 minutes, but I do want to go back to something that Andrew said. Andrew has had quite a conversion from his days as prosecutor of the Arthur Anderson case, and he says, having now studied it, he finds it fairly highly unfair, and weren't you all? But weren't you also in the Arthur? You were both. That's what I thought. And as Alice said, in the Department of Justice, they don't focus on these theoretical issues. It's the practicality of the thing. Well, I'm glad that Andrew is going around doing penance and trying to assist Ionian management. And in fact, Andrew actually cited my article in the Wall Street Journal condemning the Arthur Anderson prosecution, so you know how penitent Andrew is being here. Now, Andrew mentioned that there has been an unwitting expansion of the corporate criminal liability doctrine. And probably the best example of that is Arthur Andersen. I'm not going to be too tough on Andrew because he's seen the light. It was not a corporation. It was a limited liability partnership. Now, you know, in common law, the difference between a partnership and a corporation is that corporation is a separate entity. Whatever you want to say about corporations and being a separate entity, when you charge a partnership, the people in that partnership feel it individually. I know, because they communicated with me. I mean, they really took this very, very personally, the partners in that. Moreover, you say, oh, well, that doesn't matter, you know. The fact of the matter is, those partners are still suffering personally as a result of it. And I know it, because they left that partnership, and most of them got hired by other partnerships. But in all of those other accounting firms, there is a rule that stamps, if this person came from Arthur Andersen, their work, in terms of compliance, in terms of past conduct, has to be double-checked. Never mind that the Supreme Court reversed 9-zip on Arthur Andersen on mens rea grounds. Now, the irony is that Andrew's looking for the case. Arthur Andersen was the case, and it went to the Supreme Court, and the court said there was no proof that there was consciousness of wrongdoing, that the document shredding policy necessarily constituted persuasion that violated obstruction of justice. So, to the extent that the court has gotten to the issue in the Staples case and the other ones that I've shown, especially in Arthur Andersen, there is a concern, more so I think at the Supreme Court level than there is at the Federal Court of Appeals level, to pay attention to the distinctions between public welfare offense and true crimes, and limiting the corporate responsibility, the responsible corporate officer doctrine. And I think if Andrew can never get the case there to the Supreme Court, there may be more attention to what he is rightly focused on in Ionia. There was a particular statute in which all the court said was Congress can pass that statute. It never said that courts were required to read corporate liability into all kinds of statutes that didn't reflect any intent by Congress that it be applied to corporations. I'll leave the additional time for questions. Thank you.